So today we're going to talk about the DOJ, or Department of Justice, and the ADA, the Americans with Disabilities Act. So the ADA was passed in 1991, and it was passed during a time that the internet really didn't exist in the way it does now, where many people are using the internet to accomplish everyday activities. At the time, the ADA was meant to ensure that disabled individuals were not discriminated against in employment and doing such everyday activities. The ADA was divided into three titles. So Title I pertains to the laws that govern employers and what they are obligated to do so that disabled employees can work there. Title II deals with state and local governments, and Title III deals with places of public accommodation. With regards to Title III, thinking in terms of a time pre-1991, again, when they mean public places of public accommodation, these were exclusively physical places because this was a time before the internet was ubiquitous, and they had several categories on the kinds of places, and 49 specific kinds of places were described. Some examples of these physical places of public accommodation include hotels, retail stores, and hospitals. So what exactly is the role of the DOJ with regards to the ADA, the Department of Justice? The Department of Justice is the agency charged with enforcing the ADA, and it does it in two different ways. The first way is enforcement. The DOJ files lawsuits to enforce businesses that are subject to the ADA to make sure that they are in compliance. And the second task is rulemaking. So the DOJ is supposed to pass rules and regulations to give clarity to the ADA. What is the role of Congress? So Congress passes laws, and then certain agencies pass regulations to give clarity to what those laws mean and how they should be enforced. When the ADA was passed, it did not mention specifically the internet or websites, but in the 1990s, the DOJ started to interpret the ADA as applying to the web. And they did so by taking positions in particular legal cases. They went after companies whose websites were not accessible to the blind and visually impaired, and they joined private lawsuits. Now, some people talk about congressional intent because although the ADA was passed in 1991, it was amended by Congress in 2008. So at that time, the internet was much more prominent. So Congress could have addressed the internet, but they didn't. So some people feel that Congress never intended for the ADA to apply to the web. However, the DOJ took a different approach and said that the ADA does apply to the web content, and in 2010 they began to set rules specifically with regards to website accessibility. However, there was a general lack of clarity with what they spoke about with regards to web accessibility. In contrast, clear rules exist for physical locations, so every physical store knows how wide their doorframe has to be or how tall their sales counter needs to be to serve wheelchair-bound patrons. When, in 2010, the DOJ took it upon itself to make rules, it said it was going to make rules, but then it continued to repeatedly postpone the actual rulemaking for several years, even though they continued to engage in enforcement activity. That means they joined cases, they sued particular businesses for their practices. Meanwhile, the business community was eagerly waiting for the DOJ to actually issue specific regulations so they knew what to do and how to make their business actually accessible. What rules are they supposed to follow? And in 2017, the DOJ decided to stop its rulemaking process. And with that complete lack of clarity, that is when lawsuits exploded. So in 2017, ADA-related web accessibility cases quadrupled. And when these lawsuits exploded, Congress started to question the DOJ. Like, what are you doing? Businesses are getting targeted. They don't know what to do. What are you, the DOJ, going to do? Are you going to restart the rulemaking process? What are you going to do? And in late 2018, the DOJ responded by saying it had no plans to restart the rulemaking process and they gave no clear technical guidance to businesses. And how exactly does the WCAG fit into all of this with the ADA, with the DOJ, whatever? So the WCAG are the Web Content Accessibility Guidelines, and they were developed by an international consortium to address what a website needs to be accessible. And although they're widely accepted to be the preeminent guidelines that people should follow for website accessibility, they really don't have the force of law. So some courts decide that further regulations really aren't needed because you could just look at the G guidelines for accessibility compliance. But the DOJ generated more confusion because they stated that if you don't follow these guidelines, it doesn't necessarily mean that your website is not accessible. So again, they didn't really take a stand with regards to WCAG, and it created more confusion. And at this time, they also included the word flexibility, which was the first time they used flexibility in their statements. And they basically said that people need to have flexibility with regards to these guidelines. And this just created even more confusion, raised more questions, and didn't really answer anything. So in this environment of lack of clarity, we've continued to have more and more ADA litigation. Every year since 2017, the lawsuits have increased, and they're year by year, they go up. So finally, in 2022, the DOJ reaffirmed its guidance regarding Title III. So these are places of public accommodation, businesses open to the public. They reaffirmed in 2022 that the ADA does in fact apply to websites. Because what they said is the ADA requires businesses open to the public to provide full and equal enjoyment of their goods, services, facilities, privileges, advantages, or accommodations to people with disabilities. Businesses open to the public must take steps to provide appropriate communication aids and services, often called auxiliary aids and services, where necessary, to make sure that they effectively communicate with individuals with disabilities. And so they stated that a website, if it has inaccessible features, that can limit the ability of people with disabilities to access a place of public accommodations, goods, services, privileges, and available through the website. So this is why they reaffirmed their position, and it's the same position they've consistently taken since the 1990s, that the ADA's requirements do apply to all the goods, services, privileges, or activities offered by public accommodation, including those offered on the web. So in 2022, they reaffirmed their position. And some examples, again, of Title III, because some people are never sure, do I fall under Title III? So examples would be retail stores, other retail establishments, banks, hotels, inns, motels, hospitals, medical offices, food and drink establishments, auditoriums, theaters, and sports arenas. And more recently, this year in April, the DOJ decided to clarify the ADA with regards to Title II. So this is state and local governments. And these were the most specific guidelines they had come out with since all this lack of clarity has happened since 2017. So in April 2004, the DOJ set forth rules pertaining to Title II. So this affects state and local governments, and it applies not only to web content, but it also applies to mobile apps. So not only does the website need to be compliant, the mobile apps need to be compliant. And that is because state and local governments provide many of their services, programs, and activities both through websites and through mobile apps. And if they're not compliant, then they create barriers. And they actually stated in their rules that the requirement is that the state and local governments' web content and mobile apps follow the WCAG 2.1 level AA or AA standards. However, there are exceptions, of course. And basically what they said is state and local governments need to do this, but what they can do is they can prioritize making certain content comply more quickly than the rest of their content. And for example, that they might make compliant current or commonly used information first, and then they can slowly get the rest of their content up to speed. And then there are certain kinds of content that they don't need to bring up to WCAG 2.1 level AA standard, because this type of content may be particularly relatively hard for the state and local governments to get to right away. So what are some of these areas that are exempted? One is archived web content. And for something to meet the definition of archived web content, it must meet 4 of the following points to be considered, and then be something that does not need to meet the WCAG 2.1 level AA standard. The archived web content must be 1, created before the compliance date, or it reproduces paper documents or contents of other physical media like audio tapes, film negatives, CD-ROMs that were created before the government was set to comply with this rule. And number 2, the content is kept only for reference, research, and record keeping. And number 3, the content is kept in a special area for archived content on the website, for example. And finally, number 4, the content hasn't been changed since it was. So an example of what would fall under archived web content would be a quality report on water from 1998 in a state's archive that is stored in an area of the website that is marked archives. However, one thing to note, if a person with a disability, so for example, if a person with a hearing disability requests access to a video that's in the archive because they want to access that content and they can't because they can't hear the video, they can request for a captioned version of the video to be provided to them. So even if something's in the archive, if an individual who has a disability requests particular content, the state and local governments do need to do their very best to help that person get to that content. So maybe it's not been updated on their website, but if a particular individual requests particular content, then they need to do their best to provide that person with content that they can consume without a problem. So they would need to take that archived content, caption it, and provide it to the individual who has requested that content. The next area of exemption is pre-existing conventional electronic documents. So a lot of state and local governments have older documents like PDFs on their website, and trying to bring these old PDFs to accessibility is really difficult. So again, these documents must meet certain criteria in order to fall under this exemption. So number 1, the documents are word processing, presentation, PDF, or spreadsheets files, and they were available on the state or local government's website or mobile app before the date the state or local government is set to comply with this rule. So for example, if they have a PDF flyer of a holiday event that was posted to the town's website in 2018, that is not something that they need to bring up to speed today. They can leave that alone. However, it doesn't apply if the documents are currently being used. So for example, if they keep updating the same PDF for this year's holiday or whatever, if they're bringing that content up, if they're editing that document and they're now posting it after they've updated it, then it does need to comply at that point. So any documents that they are currently updating or presenting new information, maybe it's similar to the old information, but it's new information, that does need to comply. Another area of exemption is content posted by a third party, and that third party is not related to the public entity through a contract, licensing, or other arrangement. So third parties can post content on state and local government websites or mobile apps. So just like anybody else, these third parties are members of the public, and they're not under the control of state or local government. So the state or local government cannot change whatever they're posting. So an example, of course, could be a message that a member of the public posts to an online message board controlled by the town. The platform itself needs to be compliant, but the message does not. But there are instances where third-party content does need to comply, and so we should go through those instances just for clarity. So third-party content must comply and be brought up to WCAG 2.1 AA standard when it's the state or local government that is posting the third-party content onto their site. So because now that content is under the control of the state or local government, even though it's developed by an outside company, they need to make sure it's compliant. So if they're using outside technologies from other companies, for example, calendar systems, scheduling tools, maps, reservation or payment systems, if the state or local government is deciding to post that content on their website, then that content needs to be compliant. Another instance where third-party content must comply is when the content is posted by a state or local government's contractor or vendor. So if a state or local government contracts with a third party to do something for them, then that content needs to be compliant. So, for example, if the state or local government has brought in a third-party company to design, manage, or update the website, then any content that the company posts for the government must be in compliance. And then a third-party content issue is, again, the tool or platform must be compliant. So if they've added a message board platform to their website, while the content that the public posts on the message board may not need to comply, the platform itself that the state has chosen to put on the website must be compliant. And then another area of exemption are individualized documents that are password protected. So sometimes state and local governments will use password-protected websites to share documents for particular individuals. For example, the bills that they send to people. So if you have a sewer bill, for example. However, it may be hard for them to make all of these documents accessible right away for everybody. And of course, not everybody needs these documents to be made accessible if they don't have a disability, for example. So for a document to meet this criteria for exemption, the document must be a word processing, presentation, PDF, or spreadsheet file, and it has to be about a specific person, property, or account, and the document is password protected or otherwise secured. So for example, a PDF version of the sewer bill for a particular person's home that's available to that person in their secure account on a city's website would fall under the exception. But again, if that person has a disability, so they maybe have low vision and they're having trouble accessing the content on the PDF, then they might request the town to provide them with a large print version of the bill. So if there's a specific request, again, that person has a disability, they find they can't read their sewer bill, then the town needs to provide them with a document that they can access the information they need, even though that technically falls under this exemption, because they got a specific request from an individual with a disability. And then the last area of exemption is pre-existing social media posts. So for many state and local governments, the idea of going back to make all of their social media posts accessible is probably impossible. And there's probably also little use to doing that because typically social media posts are regarding current content, like content that was relevant at the time but is no longer relevant now. So there's no reason for them to go back and spend time trying to make old posts accessible. It's not necessary. So in general, these are exempted. For example, a social media post made in 2015 by the city's water department about a boil water advisory because of a contamination issue, that would be a post that does not need to be brought up to standards today. So are there any situations where a state and local government does not need to meet the WCAG 2.1 level AA requirement, even if the content doesn't fall under any of the exemptions? So they did put into the law a kind of an out, in the sense of state and local governments do not need to take action that would result in fundamental alteration or an undue burden on them. So these words undue burden can be interpreted in many ways. So even though we would like them to be in compliance right away, because this law has been posted in April 2024, so you would expect all the state and local government websites would now be compliant. It is an undue burden to expect that they get everything in compliance right away, and that's why they're given 2 to 3 years to comply. And they may decide that certain material has a priority other material. So that undue burden can be interpreted in many ways, and that can be an issue where what could result in some sort of litigation against the state and local government if a particular person with a disability is unable to do something on the website. And what about the use of conforming alternate versions? So what exactly is a conforming alternate version? So sometimes a situation arises where we create a version of something that is not accessible, but we also side by side provide another version that is accessible, and both versions have the same information and features. So the second version is called a conforming alternate version. And in general, we are discouraged from doing this. Why? Because people with disabilities should be able to get equal access to the content on the same page as those without disabilities. What's happened in the past in these situations where you've provided one accessible version, one other version that's for those without disabilities, is that often the updating of that content is not equal. And often the information provided to those without disabilities is updated more frequently than the versions that are provided to those with disabilities. And it's never been really a situation of equality in those cases. So in general, the use of conforming alternate versions has been discouraged, and state and local governments can only use this tactic in very limited circumstances, and that's only when there is a technical or legal limitation that prevents inaccessible web content or mobile apps from being made accessible. What if, despite all of this going on, a person with a disability still cannot access web content or mobile apps that meet WCAG 2.1 Level AA standards? If this happens, the state or local government is not necessarily required to make more changes to its web content or mobile apps if they've already shown that they're meeting the technical requirement, but they still have to satisfy the obligation under the ADA to make that content available to that person that has a disability. So in this case, where they're meeting the requirement, but there's still a person that can't get access because of their disability, then the state or local government must figure out with that person on a case-by-case basis. So they need to figure out how to meet the needs of the individual with a disability on a case-by-case basis. So what could be an example of this? If they've created a ticketing app, mobile app, and in general, they've done their best to follow the guidelines set forth by the WCAG, and there are maybe only minor errors or whatever, then the state just needs to provide an alternative way for that person to get the tickets. Doesn't mean they have to go redo their app. They just need to handle the situation with this person. And going to what I mentioned, minor. So what if a state or local government fails to meet the WCAG 2.1 Level AA guidelines, but it's only in a small, minor way? So sometimes there may be a situation that they can show that their web content is not meeting the standard, but that it's not meeting the standard in such a small way that it doesn't really make a difference to people with disabilities. And this is not, again, meant to be used as out. Like, they can't use this reasoning to not do their best to meet WCAG 2.1 Level AA. So that is in the law there, that they should still try, but if there's like a minor issue, then that can be okay. It depends. What is the nature of that minor issue? So as an example of something that would violate the rule, let's say they have many people go to the state's website to renew their professional license. Because their renewal system isn't meeting the standard, a person with disability may need more time or may need to actually get help from someone without a disability to help them. And in that case, they're actually having to give their personal information to this other person, which is not ideal. And the process is harder and they're more frustrated. So this is not, and even if the person is able to actually renew their license online, the state is technically still in violation, because this is a situation where the person is having a much harder, more frustrating, and they're not getting that equal experience with someone without a disability. And an example that meets the rule, so example, let's say they've made a web page and there's information on the page that's important, but their contrast ratio is only 4.45 to 1, which is below the WCAG 2.1 level AA standard of 4.5 to 1. So it's a very small difference. And in general, that such a small difference would not generally mean someone with low vision couldn't access the information. So if the state can prove that difference is minor and it's not impairing people's access, then that would not be considered a violation. So that's what they mean by minor way. And so how we mentioned that the expectation is now not that now they've put these guidelines in that the state and local governments' websites must and mobile apps be compliant now because it's June and this came out in April. No. How long do state and local governments have to comply? So to make sure that their web and content mobile apps meet the WCAG 2.1 level AA standard, they are given 2 to 3 years from when the rule is published, which was April 24, 2024, depending on the population size that the government services. So they'll have to go to their census data to determine what is their date. So for example, if they're serving 0 to 49,999 people, then they have until April 26, 2027 to comply. If they're considered a special district government, they have until April 26, 2027 to comply. If they have 50,000 or more persons, then they have a shorter timeline. They must comply by April 24th, 2026. So a larger state or a larger local government will, and this is all determined by current census data, they may either need to comply by 2026 or 2027. So they have a few years to do this. And what about school districts? When do they have to comply? So a school district is generally not considered a special district government. So if it's a city school district, then it needs to use the population of the city to know when to comply. They would look at the census data of their city. Are they a small city, less than 49,000 people? Then they have until 2027. If it's a larger county school district, they need to use the population of the county. And if the county has more than 50,000 people, then they only have until 2026 to comply. And if they're an independent school district, then they have to use the population estimate in the most recent small area income and poverty estimates. There's a link to go to this, and that will just be posted so that if you're an independent school district and that's where you need to, in order to figure out your compliance date, you need to go to this particular website with that information. So that's basically what's going on with the DOJ. The DOJ more recently has been more active in trying to clarify the rules because there's been a situation where we have been given a lack of clarity since 2017, and that has allowed the litigation to just skyrocket. And businesses need information to figure out how they can start to get into compliance so they can avoid these lawsuits. So the DOJ more recently has been active in trying to clarify their rules, and this will all help the situation with ADA litigation. That's all we have for today with regards to the DOJ and the ADA. And just as a disclaimer, I am not a lawyer. I have no specific legal training. So if you're looking to this presentation for legal advice, you need to consult with an actual lawyer about your specific situation because I do not have any legal background.